Well, good morning. This is Mike McCarty with Safe Hiring Solutions. I want to welcome everybody to the webinar. We waited just a couple minutes just to let everybody get kind of logged in. We still have a few that are logging in as we get started. A couple kind of preliminary or housekeeping items. One, we have started a process of using Twitter to answer questions kind of in real time as we go through these webinars. And so you see here in front of you, if you're on Twitter, you can use this hashtag SHS webinars. If you're not, for future webinars, I would recommend not only getting yourself a Twitter account. It's free. We also put out a lot of information via Twitter, so it's a nice way of getting quick little short bursts of information related to industry issues. The other couple things is we have everybody muted. That just cuts down on the background noise, so that's why we use another medium of being able to answer questions as we go through this. And we will also make a recording of this, so we'll make this available probably over the next couple of days, as well as the slides. So you don't need to try to write down all the information on each of these slides. We'll put them up on SlideShare and give you access to that information as well. Again, my name is Mike McCarty, founder of and CEO of Safe Hiring Solutions, also founder CEO of RefLink, Safe Visitor, and Safe Recruiter is a sister company we launched about a year ago. I'm president of the Indiana Background Screening Association. We formed this about 2 years ago. We're heavily involved in the legislative process here in Indiana and nationally. So I work through the National Association of Professional Background Screeners, and basically as a state captain in their legislative committee. Prior to starting Safe Hiring, was a violent crime detective in Nashville, Tennessee. Did a lot of training consulting work for like Department of Defense, Justice, Homeland Security before launching Safe Hiring 13 years ago. A little bit about us. I know many of you are clients, but you may not necessarily know a lot about us. We're headquartered in Danville, Indiana. Everything we do as a company is in Indiana. We've got our main office in Danville, Indiana. We also have a satellite office in Crawfordsville, Indiana. A couple old historic buildings that we've renovated. We have about 40 employees, 5,000 clients across the U.S. and Europe. Was one of the founding members, like I mentioned, of the Indiana Association of Background Screeners. And really what kind of prompted me to put this webinar together, we spend a lot of time, usually throughout the year, blogging, webinars, kind of really talking through kind of FCRA, the Federal Fair Credit Reporting Act requirements. But this one just seemed very timely, and so this particular case is out of Indiana. It's Petrie versus IDE Management Group. It's a home health care organization. So the lawsuit was filed back in March here in Indiana in U.S. District Court. And basically the plaintiff alleges that she applied for a job. She was offered a conditional offer of employment based on successfully completing a background check to their satisfaction. In March of 2017, the conditional offer was rescinded because of information on the background check. It was stated by the company that she had multiple felony convictions on the screening report. They rescinded the offer. The plaintiff requested the name of the background check firm and a copy of the report, which the information was refused to the plaintiff. So that's basically, in essence, kind of the meat of what the lawsuit was filed under. So kind of three areas that were listed in the lawsuit were one, that the home health care agency failed to provide a copy of the background screening report before taking any kind of adverse action. Also failed to provide, prior to taking any adverse action, a description in writing of the rights of the plaintiff under the Fair Credit Reporting Act, and otherwise negligently and willfully violated the Fair Credit Reporting Act. So kind of the goal here is a foundation to say, look, this is one that's been filed here in our backyard. It's one to keep an eye on. It's really close to home for most of you on this call because it's the same vertical, same market. And what we want to do is really look at, okay, foundationally, what are my requirements under the Fair Credit Reporting Act? Not an attorney, it's not legal advice, it's an educational seminar, but educationally, what do I need to understand about the Fair Credit Reporting Act? What are my requirements? What does the climate look like outside of Indiana as well? What's going on around the country? What are these lawsuits looking like? And so really kind of, looking at requirements, what these judgments are looking like, and also for those of you that are using us for your background screening services, point you to some of the tools that are in the system to help you manage the adverse action process to make sure that you're in compliance, so provide other layers of protection. So, one of the foundational questions I have is obviously in the lawsuit, it's an unnamed background screening firm, and one of the things I put out yesterday, I think it was on Twitter, was asking, those folks that are using background screening firms, do you know if the background screening firm is using contemporaneous notification, or if they're verifying their information, any adverse information, with the source or the court of record? In this case, it's not clear, it's not mentioned, the screening firm not named in the case filing, so we don't know about that information. It's a question, to understand, because it's at the kind of, it is the source of the lawsuit, even though the lawsuit was filed because there, certain parts of the Fair Credit Reporting Act were not complied with, giving a copy of the report, a summary of their rights under the Fair Credit Reporting Act. At the base of this, at the foundation, is an applicant or consumer saying none of that information is correct. So that's really what started this process, is these felonies that came back on my background screening report were not me, and that's why this consumer then started a process of saying, I want to see the report, I want to know who assembled the report, basically, because this information is not accurate. So understanding, kind of contemporaneous notification versus the verification with the source is really, this is something, there's no way that organizations would even know to ask this when they're vetting background screening firms. But how a background screening firm approaches background screening, this can be a critical piece to protecting you and lowering the risk of a similar type lawsuit. Because under the Federal Fair Credit Reporting Act, it gives two options for CRAs. And when I abbreviate this, a CRA is a consumer reporting agency, which is a background screening firm. And so there's two options under the federal law for CRAs. The background screening firm can do this contemporaneous notification, which means we run a background check, we see negative information, maybe it comes from a database or some source that has not been verified. We can provide that information to you as the client as long as we notify the consumer at or before the time we give it to you. So that's where it's a contemporaneous, at the same time kind of notification. It's not a good practice, not a practice that quality background screening firms would advocate, but I can tell you that it's a practice that is widely used. And so what happens is I can report information that I don't verify with the court, but a lot of times this information in a database, common name even, is very difficult to determine whether or not it's your candidate or not your candidate without going to the source. pulling the court file and seeing what kind of identifiers exist. How we do it at Safe Hiring and how a quality background screening firm would approach this is they're going to verify the information with the source or the court of record. Protects you as the client, your organization, so that way when you're getting information, it's coming from the source. It's been verified with the source. Now, does that mean the sources never make mistakes? Absolutely not. Sources make mistakes. And that's why there is an adverse action process that we're going to talk about here that in this particular case allegedly was not followed by the organization, and that's really where the violations of the FCRA come into play. It also protects the consumers. I mean, our number one goal here is to make sure that we're providing the highest quality information as a background screening firm, both to protect you and your organization, to make sure somebody that shouldn't get into your organization does not because they have an unsuitable criminal history. But second to that, we don't want to mislabel anybody as having something that is not theirs. And so we take this very seriously, protecting consumers and assuring that the information is accurate information. And quite honestly, the Fair Credit Reporting Act has a clause requiring, maximum accuracy guarantee. And so, making sure that information that we provide you is as up to date and as accurate as it possibly can be. We can't control whether or not a clerk in a court made a mistake, didn't remove information, mislabeled something. That's where the adverse action process comes in, so we can help correct that. If any of you have ever had things show up on your credit report and you started a process to correct that, it's the same process and it's governed by the same law, the Fair Credit Reporting Act. A lot of times people get confused. They don't think the Fair Credit Reporting Act applies to them because they say, hey, we're not using credit reports. We're doing criminal background checks or motor vehicle checks or reference checks. We're not using any kind of credit information. So the Fair Credit Reporting Act doesn't apply. It's probably one of the, most poorly named federal laws because it encompasses more than credit. It deals with any type of consumer report. And so if you pay a third party, so if you pay a background screening firm like Safe Hiring to compile background screening reports, then you have to comply with the Federal Fair Credit Reporting Act. And so most of what I see in this lawsuit are easily avoidable technical violations. It's just understanding what these requirements are, and that's why we like to put lots of information in front of our clients on a kind of recurring basis, because when you become a client, there's a lot of information that you're trying to digest very quickly, and though we give you this information in a couple different formats, we want to make sure that you understand what those requirements are. And so every candidate, these are the requirements, and understand that you cannot attach this disclosure statement and authorization to your application. It has to be a separate standalone document, cannot be part of the application itself. The idea behind that is they don't want somebody going through filling out an application on the final page, signing something thinking it's an application, when in fact what they're doing is they're signing away their privacy rights to allow you to run a background check. So it needs to be a standalone document. So, we've got kind of, examples of how it should look as a standalone document. If you're using our online electronic process, then it's already separate from your application, so it would meet that criteria. You've got a disclosure statement. So first thing is you have to disclose to the candidate that you may run a may run a consumer report or a background report. The language is very specific, and so when you read through it, you think, man, I don't like the way this language is worded. that is the way it has to be worded. When it's using, phrases like mode of living and that type of language, you think, that's not really clear. Well, it's formatted that way for a reason, because it has to be that way. Then you have the authorization. So now you disclose to them, then you have to get their authorization, either a wet signature, they sign with an ink pen, or an electronic signature, but they have to authorize the background check before you move forward. The back end of this is really kind of the part that is at the foundation of this lawsuit. So the back side of this says there's a two-step required process if your decision to rescind your offer or not hire somebody is based in whole or part on a background screening report. So what does that mean? Well, based in whole is pretty simple. You work with vulnerable populations and you run a background check, and the person, let's say, was convicted violent sex offender, and so in that scenario it's based on the report. You can't take the risk, and this was a conviction 2 years ago, and so you're not going to place that person in a position of going into a home with that background or criminal history. Where it gets a little bit less clear is when it says or part. How could your decision could be based in part on a background screening report? Well, here's how it could. You have them fill out an application. You're asking questions on an application about criminal history. And so you have a candidate that checks boxes that they've never had a criminal conviction. We run a background screening report, and we provide to you a report that shows that they had a conviction for DUI 3 years ago. So maybe based on your policy, the DUI would not even be an issue. But the fact that they lied to you and were dishonest on their background or on their application becomes an integrity issue. And so now you may want to rescind your offer. It's not really because of the DUI, but it is based on the background screening report, because you would never have known that they had lied without the background screening report. So my suggestion is when you start this process, you run a background check. If any part of that background screening process causes you to rescind your offer, then you need to follow these 2 steps. Step 1 is you have to issue a pre-adverse action letter. So just like it sounds, before you take adverse action, you have to provide them a letter explaining that, based on the background screening report, you may rescind your offer. You have to give them the contact information for the background screening firm and their, toll-free number. So there's 2 things right there that were listed in this lawsuit. A letter wasn't issued. B, didn't provide them the information of the background screening firm. You have to give them a copy of the report. They have the right under federal law to see the background screening report that's being used against them, and a summary of their rights. You have to provide them a summary of their rights under the Fair Credit Reporting Act. That's step 1. And then step 2 is I take adverse action. So I have an adverse action letter. And so the idea here is step 1, a consumer has the right to review and dispute inaccurate information. So in this particular case, presumably if these allegations are true and these steps would have been followed, then this potentially could have been resolved very quickly by disputing the information with the background screening firm, saying, I've never been convicted of these felonies. This is not me. They have to reinvestigate, and if they cannot show that that is that candidate, they have to remove that information from the report. And so step 1 provides that opportunity. Step 2 is the final adverse action. So it's a 2-step process, and it needs to be separated by a minimum of 5 days. And so a reasonable amount of time has been pretty clearly defined as at a minimum of 5 business days. So the idea is if you're going to print this, mail this, which I recommend, I would not email it. I would mail it certified. You have receipt to the address they provided you. You got to give them enough time for that to be received and enough time for them to have reviewed it before you issue the adverse action letter. Here's just a few examples of some of the willful non-compliant FCRA suits over the last few years and what those numbers look like. This one, Hunter versus First Transit, was not providing disclosure to the applicants before running a background check, failed to follow the two-step adverse action process, $5.9 million. The one thing I did notice in this lawsuit was they included class action. And so though only one person was named, there could be more named in this lawsuit. So you can see it's pretty large judgments, and you can see here some fairly big brands that have had the same issues. Domino's Pizza, $2.5 million. Kmart, $3 million. Walt Disney had a pending. We've seen background screening firms sued for FCRA violations. And so these are all multi-million-dollar judgments. Here's a couple examples of technical violations. And when we start talking about technical violations, these can be very small violations, and just by not following the proper steps, you know, that can cause or trigger these type of lawsuits. And so in this particular case, they're saying that they basically violated the Fair Credit Reporting Act because they were not providing a standalone disclosure, and that it was part of the application form. We talked about that at the onset. It needs to be separate from your application. Or in this particular case, that they alleged that Paramount violated the Fair Credit Reporting Act because a disclosure in the document that consists solely of the disclosure was not present. The big key here is there was also a release from liability. So on your disclosure statement and authorization, you cannot add a release of liability to that. That is, it would not conform to the FCRA disclosure statement authorization process. This one's an interesting case. What was happening in this particular case is they were initiating the pre-adverse action process, but they were not going back and completing the two-step process and finalizing it with the adverse action letter. So they started step 1, but they were not doing step 2. So very small technical violation. Actually, in terms of the consumer, they were receiving the most important piece of that two-step process, which is the notification, the report, and the summary of their rights. But it shows you that, you know, the two-step process is a requirement and can be the foundation for a lawsuit. How to manage this? If you're using our background screening system, we actually went to some links here to provide a little more foundation for managing this and make it a little cleaner, an easier process to conform to. And so when you log into the system, if for example here, I'm going to run, you know, we ran a background check on Fred Flintstone. Fred comes back, and in this particular case, we're going to deny Fred employment based on the background check. So I need to initiate this process. Instead of having all these forms on your computer and you're trying to determine, okay, which one and how do I do this? If you go, you know, and open up Fred's profile, you'll see where I have it highlighted here, there's a compliancy link. When you click on that compliancy link, it will actually take you to a page. And within this page, what you're going to do is you're going to click on this link over here on the right that says Add Letter. The system is intuitive, so the system knows that we have not done anything with Fred Flintstone or Sammy test name, and so it knows the first step is the pre-adverse action. And so once you click on Add Letter, it is going to create the pre-adverse action letter because it knows you haven't done that yet. It's going to give you an option. It's defaulted to postal. You can switch it to email. That's policy driven on your end. My concern with email is because so much email is, undeliverable, ends up in spam boxes, somebody didn't receive it, that if you send it through the post office certified to the address provided, by the applicant, that's probably the safest way of doing this. We provide both options. And so it's preset to postal. You're going to click on Create Pre-Adverse Action Letter, and then the system just created everything that you need. It created the letter, it created the summary of their rights under the FCRA, and then you can also have the option of printing the copy of the report, which is a requirement. So now you have your information. It prints that information, and I mentioned, now you're going to wait a reasonable amount of time before you issue the adverse action letter. And so now, you could set a calendar notification to come back in here. The other piece is on your home screen. When you log into our system, you'll notice on the left-hand side as a plug-in, there's an adverse action manager. It's probably set to 0 in your account right now if you have not initiated anything in the system. Once you initiate the pre-adverse action process, it's going to put a number. You see where that red 2 is at? That is indicating that I have initiated pre-adverse action on 2 candidates. So now it's front and center every time I log into the system. It's managing this. Now, once I've waited, my 5 or 6 business days, and I'm going to come in here and do the final step, which is the adverse action, I click on that, and when it opens up that pre-adverse action manager, it's going to list anybody we have in there. So in this case, I've got Sammy test name. What I'm going to do with Sammy is you'll notice off to the right there is multiple options here. The first option, if I'm going to continue on in the process, is this green circle with a check mark in it. When I click on that, what it's going to do now is it's going to create the adverse action letter, of which I'm going to print or email to do the final step for this candidate. Once I do that, it will disappear out of that adverse action manager. So not only do we integrate the forms to make compliance easier, we also have created that manager to help you remember to do both steps in that process. So that's a lot of information. I know we went through pretty quickly. Again, I'll make the webinar available as well as the slides. Here's my contact information. We've got recurring webinars we do on a monthly basis. So generally we have them up on the website. We'll probably send out blast emails periodically. But if you go to the website, click on the resource tab and click on webinars, you'll see upcoming webinars that we have. If you have questions, feel free to reach out, and we'll be happy to walk you through the process again. It may be that it's months before you actually use an adverse action process and you think, wow, it sure could use a refresher. We have a client service team that are more than willing to grab a phone call and walk you right through the process to make sure that you do it correctly and make sure you understand how to do it, because it's really not that difficult. It's just making sure that each one of those steps are followed correctly. I'm going to pause here for a second and see if there were any questions. All right, I'm not seeing any questions, so we appreciate each of you taking time out of your day, and we look forward to seeing you on another webinar. Have a great day. Bye.